We're going to go ahead and start this meeting off this morning a little bit out of the agenda. We have Grover Robinson here. He's our county commissioner. And we have Buck Lee, and they have to go to another meeting very, very quickly. So we're going to get them up and start off with Buck Lee, the general manager of the Santa Rosa Island Authority.
Thank you. I don't know if you can hear me back there. I'll stand in the middle or whatever. I'll let you know we're doing everything we can to clean up this beach. We've been very fortunate. We haven't been hit like Perdido Key and Orange Beach and Okaloosa Island, but we know that it's out there and it's probably going to come. And that's what the meeting is this morning that Grover and I are going to down at my office, to make sure we have the proper equipment here so when it does come, that we can clean it up quickly. We're going to be working morning, noon, and night on this project. So if it does come, it's going to be gone. It comes in fingers, and you may have 500 yards that are just fantastic, and the next 500 yards has this brown-looking mousse on it. So whether it's 2 o'clock in the morning or 2 in the afternoon, we're going to be out there working on it. That's what I'm getting Grover with this morning, to make sure we have the proper equipment to go forward. Like I said, just keep praying for a north wind, but I don't know how much longer we can live like that. So we're going to be prepared when it does come. Thank you.
Buck, thank you. And I can tell you Buck's been working very diligently. The county, in fact, I think local government has been working more, whether it's the Island Authority, your county, your cities, or anything else, than anybody else in trying to defeat this combatant we have out there in the water. But we continue to keep working it. I understand you're here for claims, and I very much appreciate what you're working with. The county right now, we're in our 5th different claims process, so we understand the frustration and the headaches of having to continue to file over and over again for things that you've been told you will get paid for. I want to tell everybody that is here, the state of Florida is taking testimony on Wednesday over in Tallahassee. We have secured, I've talked to Jeff Taggart, who's given me his nightmare story. I told him, I said, well, why don't you go over to Tallahassee and testify? He's going to testify. I've sent the county experience over as a part of that also to be read into the record. If anybody else wants to testify to go over there about the process, we'll be more than happy to set it up for you. You do need to go to Tallahassee, but we can arrange a time for you. You can call my office at 595-4940, and Becky, who is my assistant, will set it up for you to go over to Tallahassee and participate in that. Again, we understand your frustration, and we're trying to work as diligently as we can, either here locally or when we testify over in Tallahassee to the state, to make sure that the claims get processed and get paid. We're right there with you on a claim. We've got claims in that need to get processed and paid, and we'll keep working it. But thank you for your patience and continuing to work with us. We're going to do all we can to make sure we can handle this. Thank you. I do have a meeting on Tuesday night at the Island Authority. Of course, if we get this many people in, Buck, we may have to move the meeting. We were kind of thinking it was going to be along the lines of what was being discussed, some issues along the lines of with what's happening with the taxation situation. If people want to pursue other options, that was what it is. But clearly we put on there, we're going to talk about everything. I mean, whether it's the oil spill, anything else that anybody wants to talk to. So we will be having that the June 22nd, Tuesday. It's going to be the Island Authority from 6 to 8, and we may look at changing the venue if and we may go to the church if it ends up being this many people. But we certainly understand, and we'll adjust accordingly. But thank you very much. Robert.
What we'd like to do this morning, and I'll speak as loud as I can. Is it any better in the back? Yeah. Okay. There's 2 or 3 things we would like to go over this morning that are of huge concern, I believe, to everybody on the island. One is for the approximately 2,000 people on the island that depend on rental income. We know it could be devastating with what this island's gone through between hurricanes and the recession. Most people cannot withstand not receiving their income on time. We make most of our money around here in 80, 90 days in the summer, and it's critical that we don't have a lapse in that stream of income for at least 2,000 people on the island. So for the last 50 days, we've been spending about half of our time trying to get a meeting set up at a top level with BP. We finally got that meeting. It was this week, and we had John Goforth, who is over all claims for BP in Alabama and Florida. He sent down 2 independent forensic accountants. We had our accountants. Andrew was there, I was there. It was a 3-hour meeting, and I got to tell you, obviously we can't speak for BP, but I can tell you it was a very, very positive meeting. What we asked for is that they not play games, they not bog people down in bureaucracy and paperwork, and that they get this money to people on time. And what they have agreed to do is at least pay what people earned last May, June, July, and August, a minimum of what they brought in 09. There's going to be a battle, I believe, because last year was a serious recession, and this year, obviously, we were on track to do considerably better. We asked for a 20% increase. They have not agreed to a 20% increase, but, you know, we're going to pursue that. I think there will wind up being some increases. So what they're asking people to do is to make sure, as they file their BP claim number, that you guys have documented last year, month by month income for the summer. Make that clear. You can show what your trend was. If you were trending up this year over last year, they want to see that trend. They're not going to guarantee that they're immediately going to pay that, but they are telling us they're going to very, very quickly pay what you were getting last year, which what we pounded on them was, if not, people can go into further foreclosures, people can go into bankruptcy, and it's going to cost BP 10 times more when they have to pay for those type of damages versus paying people on time and keeping them afloat. So I believe that was a productive meeting. We have also asked that BP send a team specifically for Pensacola Beach. We've offered them the building that we have across this bridge on the right that they could set up. They're going to be looking at that building on Monday. They can have that building if they'll set up a team there where people on the island can go in and get face-to-face contact with BP to get their claims filed quickly. That's our goal with that. I know that there's further economic issues we're all going to have to deal with, and we have the Levin Law Firm. Mark Proctor here is the president of that law firm that's going to be speaking on legal remedies. And some of those issues we're going to have is potential diminution of property values. That's a big deal to all of us. It's complicated. I'm not going to get into that. Mark Proctor's here to get into that. So that's another issue we have. The next thing we've tried to do, and we started this, actually I'll explain a fund that we have. It's a Portofino Island beautification and benefit fund, and that funds $500,000 a year to the Santa Rosa Island Authority. They do whatever they need to do with it. There's another $500,000 a year that goes into a dedicated specific fund. Currently, there's just over $1 million in that fund. Ultimately, that's going to go, and it's a 99-year fund. It's $200 million over 99 years. It has to stay on the island indefinitely for infrastructure and beautification. What we asked BP to do, I went to a meeting 50 days ago when the oil just hit, and it was a public meeting, and the Attorney General was there, Bill McCollum, and I presented an idea because I've been working on this for a couple of years to get a high level of music to Pensacola Beach where people can have their feet in the sand, and we can bring the artists that are already in Biloxi to our beach and have something positive for the residents of the island, for Escambia County residents, and would also help tourism. We believe that is a true win-win. So we've been working on that for a couple of years. We pulled $375,000 out of the beautification fund. We brought in 7 consultants. I sat on a steering committee with 13 other members. And currently there is a plan that would call for a beachfront park with an amphitheater that we're hoping to build. in a couple of years, and we're hoping to dedicate that to Alan Levin, that's no longer with us, that helped set up that fund, and we could not have done that fund without Alan. So that's the game plan for kind of a longer term period. The oil hit, and I presented this idea of bringing in a stage immediately. I called Marilyn Hess, who owns the piece of property that Margaritaville is sitting on. She is not currently going to be using all that property, and there is 10 to 15 acres left there by the pier of upland beach area. She has agreed to allow the use of that property for a year or two and have a stage set up and make Pensacola Beach the center of the Gulf Coast relief. And how that would work would be, we're very fortunate to have Margaritaville. Jimmy Buffett is obviously very passionate about the Gulf Coast. He grew up here. He's currently involved in different remedies and politically to keep the attention on the Gulf Coast cleanup. And what we want is to keep that attention alive for as long as it takes to 100% restore the Gulf of Mexico and all of our coastline. It's not going to happen overnight. I don't think this is the end of the world. I think it can be fixed. It's got to be fixed. And we want the attention to stay on that fix at a very high level. We believe the correct stage set up immediately with Margaritaville and their executive team that produces their music has agreed to get involved in that project, help with that project, and Maryland has agreed as long as that is a not-for-profit venture and any ticket sales above and beyond what it takes to get some of these artists here would go back to the Santa Rosa Island Authority into a separate fund that they would decide how it is spent to benefit the island and the ecosystem of the island. Okay, so that process started. The Attorney General asked me to write a letter. I wrote the letter. It went to him. He got it to BP. We asked BP, I asked BP 50-something days ago, or whenever that was, May the 6th, the letter went out, for a few $1 million to kick this off. 50 phone calls later, it did go up the chain of command, and they have denied paying for that. Now, I think one of the reasons is they agree it's a good idea. If they did it for us, I'm sure they'd have to do it for everybody. That's not going to happen. The good news is BP has given millions of dollars to the state of Florida, and we got at least $1 million in Escambia County to advertise our beaches, and they can choose to advertise a concert series with that money. Maryland has agreed graciously to not donate, but allow the use of that piece of property as long as the profits go back into the island to help the island through this process, which that is probably the biggest piece to this. Nobody has a 10, 15 acre piece of Gulf front property with upland beach that's available for that. That is a extremely expensive piece of land. She's allowing that. What we are doing is we're going to the Santa Rosa Island Authority. Okay, so some people are saying they cannot get in on the conference call. Would there be a limit to how many people can get on that conference call? Should not be. Okay. What we are doing is there is $1 million sitting in the island beautification fund. We are going to be offering $500,000 of that to the Santa Rosa Island Authority so that a stage can be purchased, brought in. It's a movable, large stage with the correct sound equipment to have this level of continued series of concerts on Pensacola Beach. We believe with Margaritaville helping with that process, it could be extremely beneficial to Pensacola Beach, bringing people to the island in a time that they're not readily coming to the island. It would go on through the fall. It would kick back in again in the spring. We're also trying to get a high-resolution screen so that there can be island movie nights. There can be different concerts brought in by satellite. There could be NASCAR races. There could be Monday Night Football. give a reason. I know that with Buck has proven with his success of bands on the beach, when 4,000 people come out to listen to a band, people want a reason to put their feet in the sand, and they want to do it in the evening when it's cool. Families come out, and we believe this could be a very good family continual event for Pensacola Beach. So that's where that project is. It is on the agenda for Wednesday night at the Santa Rosa Island Authority. And the main focus we need to do here is get people paid on time to keep them afloat, and then restore the island. And I think we need to keep national attention on Pensacola Beach and the Gulf Coast for the next year or two to make sure that happens. And also Martin Levin works basically full-time for the Kennedy Foundation. I spoke with Martin last week. He believes he can certainly, he works with the Kennedys, he can get the Kennedys here, and we can keep the limelight on fixing this problem and preventing this problem from happening again. So that's the goal, is to get it fixed, to keep the attention on better redundancy so these type of problems will never happen again. So those are the two goals I have. We've also got this morning Chip Kirshenfeld with Emerald Coast Keepers. I think I saw Chip earlier. Chip, can you come up, please?
Right there. Good morning, Rob.
I'm going to turn it over to Chip.
Thanks, Robert. Good morning, everyone. I was asked to talk to you a bit this morning about the ecological and environmental problems that may occur.
Louder.
Okay. I was asked to speak this morning about some of the ecological and environmental problems that we may see here as a result of this disaster. I've been a marine biologist here in Northwest Florida for about 30 years now, and this potentially could be the worst environmental disaster that we've seen in my lifetime anyway. We're starting to see tar balls, of course, on the beaches. We're seeing tar balls here in Santa Rosa Sound and along Gulf Islands National Seashore. I've been taking helicopter flights every few days to look at the location of the oil sheen and also the orange-brown moose that was very evident in Pensacola Bay and Perdido Bay on Monday and Tuesday. The good news is the flight yesterday looked very good. The water quality has improved due to the northwest winds and the west winds that are keeping some of the oil product from coming in the passes. But I did want to just give you a quick scenario of what potentially could happen to the natural resources here that brought many of us here to own property and live here in this area. With the inundation of oil in Pensacola Bay, we could very well see the loss of tremendous acreages of salt marsh, as well as the submerged aquatic vegetation, the seagrasses. If that occurs, that is the very base of the food chain, and we could see tremendous losses in all of our recreationally and commercially important fisheries. Included here would be the shrimp and the crabs, the oysters, the redfish, the speckled trout, even the snapper and grouper that come into Pensacola Bay during certain times of their life cycle. So the potential is tremendous to really lose those natural resources. If we lose the salt marshes along the shoreline, there is the potential for a tremendous amount of erosion and loss of property, because those salt marsh plants, just like the sea oats on the beach, help stabilize the shoreline. So there could be an exacerbated, a more rapid erosion that occurs as we lose that vegetation along the shoreline. Last Monday, we had oil enter Little Sabine and had oil on the stalks of the Spartina plants, the shoreline emergent vegetation. So that's really one of the first impacts we've seen here on the Sound side. In preparation for what's to come, Ned McWilliams, who works with Mark Proctor here at the Levin firm, collected pre-impact data, water quality data, sediment data, as well as oyster tissue data, in preparation for analyzing what natural resource damages are going to occur in the future. So having that data and having the forethought to collect that data several weeks ago before we really had any impacts will establish the baseline for any future natural resource damage claims. We're all hoping for the best. We do have a very optimistic view today. In the helicopter flight yesterday, there was no oil sheen at all in the bays or along the beach. So we're very fortunate with the northwest winds, the west winds the last couple of days that are keeping the oil product offshore. We hope our luck holds out. So far, we haven't had any tremendous damage, but with the data that's been collected, the Levin firm is prepared for that natural resource damage assessment. Thank you.
At this point, we're going to introduce Mark Proctor, the president of the Levin Law Firm. Mark Proctor is a full-time resident of Pensacola Beach. He's a personal friend of ours. We are very fortunate, we believe, to have a law firm of this stature with the economic strength that can fight something like this that could take years. One thing I've gotten repeated question from leaseholders concerning hiring a law firm, and my understanding, they'll explain it further, is that for all the interim claims that BP was going to pay and is going to pay, they don't charge cost or fees from that. So that was a confusion. We thought it was important to get the law firm here to explain potential diminution of value of real estate and have him take you through how the process works. We are going to, after Mark finishes, it'll be maybe 20 minutes or so. We're going to continue on with a couple of other short speakers, and then we're going to open it up to questions. We also have Mort O'Sullivan here, CPA, that can answer any questions concerning what type of documentation you're going to need. So I'm going to turn it over to Mark Proctor.
Thank you, Robert. I'm going to take just a very few minutes and then going to ask Brian Barr, my law partner, to take us through a video presentation that I'm going to ask everybody to come up for. I'll tell you when to try to move up. I know it's crowded in here, but I think this is an effective and an efficient way to take you through what's going on with the constant state and change of the law as it relates to this disaster, and what remedies are available to you, what remedies we suggest that you consider. And then once we finish the presentation, I'll perhaps ask some questions that I would ask if I were sitting in your shoes and try to answer them about legal fees, about how the process works, and then we'll move on to a couple of, as Robert said, additional speakers, and then we'll open the floor up for questions. So bear with us. I am an environmental lawyer. Our law firm, among other things, has been dedicated to the practice of environmental litigation for many, many years. I moved to Pensacola 30 years ago from Tallahassee, where I was the general counsel for the State Environmental Agency. I've been practicing environmental law in the Panhandle for many years. My partner, who you are familiar with, Mike Papantonio, has been an environmental activist for many, many years. And so we got together with our partner, Fred Levin, and decided that one of the areas of law that we wanted to devote a considerable amount of our time and effort was environmental litigation. We joined forces about 12 years ago with Bobby Kennedy, Robert F. Kennedy Jr., who's also an environmental lawyer. I'm sure you've seen and heard of him. And we have been engaged in the practice of environmental litigation throughout the United States since that time. I think it's important to recognize when you're thinking about a lawyer, particularly in a crisis like this that is of incredibly huge proportions, that you look for a lawyer and a law firm that, number one, has experience in environmental litigation, doesn't just advertise that they're environmental lawyers, but has experience in environmental litigation. Ask the questions. If you're considering hiring a lawyer, ask what experience that lawyer or that law firm has in the area of environmental litigation for many reasons. The number one, and I'll talk about it in just a second, is how this litigation is going to proceed, and the importance of the significant firms getting together and channeling this huge litigation in a way that will appropriately serve clients. Number two, environmental litigation, and in this litigation, the numbers that are being talked about. We're throwing around billions of dollars like they're small potatoes. This is huge litigation, and environmental litigation, by its definition, is extraordinarily expensive litigation to undertake. When you're dealing with an oil company, when you're dealing with the business establishment engaged in activities that can degrade the environment, you are dealing with the largest, most powerful, richest companies in the world. Their litigation strategy has always been, and will always be, to make plaintiffs go away by spending them into oblivion. There is a recognition, and it is a simple recognition when you think of it, that you or everybody in this room together cannot outspend BP. They know that, and they embark upon a pattern of delay by spending money. We had a case in West Virginia where we filed suit on behalf of thousands of people that inhabited a little town by the name of Spelter, West Virginia. We filed this claim against DuPont because there was a zinc smeltering operation in this little town that polluted the entire town, polluted people's homes, devalued property, polluted the playgrounds that the kids played on, and so we filed suit against DuPont. After 7 years of litigation, we got a very large verdict, a $385 million verdict that has been on appeal in the West Virginia Supreme Court. But the moral to this story, and I just say it to illustrate the fact of how expensive the litigation is we spent $12 million litigating against DuPont. This was not money that came from clients. This is money that was advanced by the law firm. But the point is, you've got to have somebody on your team who is capable of being able to fight the fight. There are a lot of people, as I say, that are advertising themselves as environmental lawyers, but there are probably 10 organizations, legal organizations in the country that practice environmental law on any type of sustained or continuous basis. We're one of those legal organizations. What is going to happen in this case? You've read the papers. There have been all kinds of cases filed. There have been class action cases. There have been cases under the Oil Pollution Act. There have been all types of claims filed in Louisiana, Texas, Mississippi, Alabama, and Florida. We filed many of those cases along with a consortium of lawyers that are true environmental lawyers that do what we do. And what will happen about 30 days from now, there is going to be a panel of 3 federal judges called the MDL panel. MDL is short for multi-district litigation. This panel is going to assign these cases to a federal district court somewhere in the United States. It could be Florida, it could be Louisiana, it could be in a non-Gulf Coast state, but somewhere in the United States. And the purpose of that consolidation will be so that one court can marshal all the cases that have been filed, conduct discovery, deal with all the pretrial issues in a consolidated way, and then when cases are ready to go to trial, if there has been no settlement, send those cases back to the venues where they've been filed. For example, if you have a claim to file in court, you'll file your claim in Florida. You'll file your claim in Pensacola. At some point in time, once the multi-district litigation is completed, in other words, all of the pretrial information has been generated, your case will be sent back here because that's your right under the Constitution to have your case tried here. What happens in these massive multi-district litigations is the courts form a plaintiff steering committee. That is a group of lawyers who will help, under the guidance of the federal court, steer the litigation. That plaintiff steering committee will be made up of law firms like us, the experienced law firms, the law firms that deal in this area, the law firms that are well-financed, and the law firms that have the requisite expertise to make this litigation go forward. And that's how this is going to work. So make sure when you think of what's in your best interest, what lawyer or law firm to hire, ask these questions. Whether you end up hiring us, some other firm, that's your business. But ask these questions, because only when you get the answers to these questions are you going to know what is in your best interest. The law in this area is changing by the day. There have been class actions that have already been filed. We have filed, as I said, many of them. You've read in the paper about a class action that we filed last Friday. This was a case filed in federal court seeking to establish a class consisting of condominium owners within a half a mile of the Gulf in Escambia, Santa Rosa, Okaloosa, Walton, and Bay counties. The purpose of this complaint was to establish and pursue a class of action for diminution in property value for owners of units that do not rent. There are all types of factual scenarios. You may own a condominium or a home and you rent that establishment. You have a claim for economic damages caused by the oil spill. Florida law is very, very tough and restrictive on diminution of property values. And so we had to come up with what we thought was a realistic option for people who didn't rent, because their claims are very, very difficult because of the restrictive nature of Florida law. We hope and we believe that this case that we just filed will be such a vehicle. We'll be considering amending that class as we go forward to include potentially property owners who are not condominium owners, single-family owners, owners of land that do not rent. Our effort is to make sure that there is a remedy, some claims remedy, whether it be in the court system, under Florida or federal law, or under the Oil Pollution Act, that piece of federal legislation that was passed by Congress after the Exxon Valdez incident. We want to make sure that everybody has a realistic claim for their damages. And so by looking at these potential different avenues, we are seeking to come up with a strategy that, depending upon your facts, depending upon your circumstances, will provide you some sort of effective remedy. Now, we know you've been reading the paper that there has, as of the day before yesterday, been established at least an outline of a new federal claims procedure. The procedure that will be put in place as a result of the agreement between the federal government and BP for BP to establish a minimum of a $20 billion compensation fund funded over 4 years at $5 billion a year. This will be a fund administered by an independent organization. Ken Feinberg. Ken he's a dear friend of ours. We've worked with him for many, many years. He is a lawyer in New York City, and he's done many things over the years in terms of trying to resolve conflicts. That's his specialty, is conflict resolution. But he was the special master that was appointed by the federal government to handle the World Trade Center disaster, the claims for compensation brought from that tragedy with the families of people who lost their loved ones. And so that is his experience level. This is obviously a very different situation. This money will be coming from BP. It won't be coming from the federal government. Fortunately for us, we know this fella, so we have the ability, hopefully, to make some suggestions as to how this process will work. But right now, when it comes to this process, there's simply more questions than there are answers. There have been no rules promulgated. There have been no regulations as to how it's going to work. You're familiar with the interim claims process, a difficult, a slow-moving process. Robert has been working tirelessly on everybody's behalf to get the attention of BP, to get some people in our area who are high enough up on the chain of command that significant decisions can be made. We've been doing the same thing, and that's in the works, and you will continue to file your interim claims. If you have an interim claim to make for your losses, call BP, get a claims number. You've got to have a claims number. Work with your accountants to establish what documentation is going to be required, what documentation you will need. Mort O'Sullivan is going to speak in a minute about the type of documentation that goes in to this kind of presentation, and file your claim with BP. If you need assistance with your claim, let us know. As Robert said, and I'll go through this in the end, there aren't going to be any lawyer's fees or costs charged for interim claims. So continue to do that. This is hopefully the avenue that will keep you afloat until everybody can get a handle on the scope of this disaster. At some point in time, you'll have a permanent claim to file. That is a claim where you will seek to establish your damages, not only your damages that currently exist, but your damages that you reasonably expect to, within a reasonable degree of probability, will exist in the future. But logic tells us, in order to make that claim, number one, the gusher has to be stopped. The scientists have to be able to say, this is the totality of the damage. The experts have to be able to say, this is what is going to be required to clean this up. The experts have to say, this is how long it's going to take to clean this up, so that your losses over time can be computed. Everybody has 3 years to bring their permanent claim. Currently, it is a claim that can be brought under the Oil Pollution Act, an administrative claim followed by a 90-day review period by BP, and then, if you are aggrieved by that process, a claim in court. This may be altered by this new federal claims procedure. We don't know, sitting here today, whether the federal claims procedure will come first, whether you can choose the federal claims process versus the BP claims process. Lots of answers that are going to have to be developed. I think these meetings are great ways to try to get information out. We see our primary mission at this point is to get information out. The more you know, the easier it is to deal with the worry and the fear that we all share. Information and education and knowledge helps all of us deal with what right now is the unknown. We've also had, and my partner will talk about this in a second, a change in Florida law as of day before yesterday. The Florida Supreme Court has decided a major case dealing with the rights of fishermen, but we feel that that decision is going to have far-reaching impacts to more than fishing interests in this disaster. So Brian is going to talk to you about that. The important thing, I think, now is to get as much information as you can so that you can analyze your situation, File your interim claims if you have immediate damage. Find out whether you're going to pursue your interim claim yourself or whether you need a lawyer. If you feel you need a lawyer, ask the questions I'm suggesting that you ask to whoever you're talking to. We're happy to provide information, and I hope that more of these type meetings will be held. I think it's an efficient way to get information to people. This is a crisis beyond all proportions that any of us have seen. There is a tremendous amount unknown, more unknown than known. Changes in facts are occurring every day. Changes in circumstances are occurring every day. Political pressures are changing legal remedies and alternatives every day. One of the things that we take seriously, and Robert has talked about it as well, is keeping not the eye of the nation, but making sure that we as a law firm, on behalf of our clients, establish the presence and establish a light that is defined on our situation. If you've been watching TV lately, you've seen my partner Mike Papantonio all over MSNBC and Fox News and CNN, and that is because he does like to hear himself talk, but that is because it is important when the structure of the multi-district litigation be set up, people will turn to the firms that have been out front in this crisis. This is the way it works. We know how it works. We've been doing this for a very long time. And the more that we can affect the process, the more good we will be able to do for our clients. And that is what this is all about. The system that we operate in, which is litigating against big companies, whether it's in the environmental arena, whether it's in the pharmaceutical arena, the system that we live in and what we take seriously philosophically is a recognition that one person, unfortunately, has literally no voice. 100 people have very little voices. Big business and industry have the voices. They've got the money, they've got the power, they've got the access, and unfortunately in our society, that makes a difference in the way litigation is undertaken. The Lady of Justice is supposed to be blind, the blindfold. Justice should have nothing to do with money or status or power. But it does. Access to the courtroom has a lot to do with all of those things. And what we do is we take our role of being your voice, if you will, seriously. Somebody's got to level the playing field, or your rights will be stomped out. We see our role as being that leveler, coming in under a contingency fee system so that you have access to the courthouse, coming in a well-orchestrated, combined effort of our firm and firms like us so that we can effectively battle any organization in the world. That's what it takes to undertake the battle that we are all undertaking together. That's where we see that we fit in. That's what motivates us every day, and that's what we pledge to continue to do as this litigation develops. If you can't get your questions answered today, or if the answer is we don't know, it's going to take a few days or weeks or months as we see how some of these things develop, and you want information, give us a call. We'll be there. We'll answer. The more information we can give to you, no matter what you end up doing, the better we think the day is, because you need to be armed with information to effectively protect yourself. So, with that said, I'm going to introduce my law partner, Brian Barr. Brian heads our environmental litigation department. I know that this is not the best way to do this in an overly crowded room where many of you can't see. I'm going to ask you to try to come forward, because the most effective way to use our time is for Brian to outline the potential legal remedies available and the options available through a PowerPoint presentation. After he completes that, then I'll come back. I'll talk about how fees work, because I know that there may be some misunderstanding. And whatever you do, you need to know what the contingency fee system is about, how it works. You need to understand that there are not going to be fees on interim claims. We'll take questions about that, and then we will open up the floor to questions. Brian Barr is an environmental litigation specialist. He heads up the environmental litigation department at Levin Papantonio. He's extremely experienced. He litigates in the environmental setting all over the country. He has for many years. He's extremely knowledgeable about the facts and the law concerning the BP disaster, and he'll take us through the legal remedies. Brian.
Thank you, Mark. Hopefully everybody in the back can hear me. I do want to make an announcement to the people on the phone. If you're talking, everybody else on the phone can hear you. So please put your phone on mute or don't talk, because other people can't hear what's going on if you guys are talking in the background. So we would appreciate that. Thank you. Now, what I want to kind of do here for a little bit is walk you through what the law actually is and what your potential remedies are. Now, we, like Mark said, have seen significant changes in the law this week. And unfortunately, this is likely to be a moving target for the next several months. There has been a significant change in the law as far as Florida state law that I will talk about. And then we all know about the $20 billion fund that's been established that could be a complete reversal and change of everything that we know about the Oil Pollution Act and how to recover. Right now we don't know whether or not the interim claim process will continue once the fund is established. There's some thought out there that the interim claim process won't continue because BP has been so horribly ineffective at administering that process. And the idea is to get an independent third party in to help administer these claims in a much more efficient process, and a person that isn't so much interested in BP's bottom line, but in the people that have been affected's bottom line. That should make it more efficient, but we don't know what the actual process is going to be at this point in time. We have some bare bone details on it that I'm going to talk to you about, but we don't know the intricate details. Now, you're going to have to forgive me. I did not get a clicker today to click through the PowerPoint, so I've got to back up here and kind of stand behind the computer and click through it. But it might help if I'm not standing in the middle of the screen anyway. All right, here's your potential remedies in Florida. The first thing a lot of people don't know about is the SBA loan program. That is a program through the federal government. It provides small business loans up to $2 million for over a period of 30 years at 4% interest. Certainly nobody wants to have to take out a loan in this situation. And I know a lot of the people on the beach have already had to do an SBA program type loan because of Hurricane Ivan. And that's certainly going to complicate the ability to get a loan under this program. But if your business is struggling and you're worried about current cash flow, this is an option you need to look at. The main office is on Chase Street, so just go down there and make an application for the loan. The worst they can do is say no. So that's something to look into. You also have the Florida Disaster Loan Program that Governor Chris just set up. Now, there's some question as to how effective this is actually going to be. It's a $25,000 loan for businesses with less than 100 employees. It's interest-free and it's available in 12-month maturities. But right now, it's only got $5 million in the program. So and it's over multiple counties. So there's a good chance that funding is going to be exhausted pretty quickly. The third option that has just been discussed is the BP escrow account. That's the $20 billion account that I will talk in more detail on. Now, as far as legal remedies, the best option out there right now is the Oil Pollution Act. The Oil Pollution Act was established in 1990, specifically in response to the Exxon Valdez oil spill. It's complicated, and there are some aspects of this situation that don't fit real well into the statutory model, and I'll talk about that. You also have federal and state RICO claims. That's one of the lawsuits that Mark's talked about that we brought on behalf of condominium owners on the Gulf. It's essentially a civil criminal type proceeding. We believe the conduct of BP was criminal. And everything we're seeing indicates that it was criminal. And this is an opportunity for private citizens to essentially prosecute BP for their crimes and expose BP for the criminal that they've been. We think it's going to be a very effective tool to putting pressure on this company. I mean, and maybe people don't know this, but BP is a criminal. They have pled out to felonies in the past. It shouldn't surprise people that they're acting like they are. There was an oil refinery explosion in Texas multiple years ago that BP actually had to plead to manslaughter because of the way they handled their business. And so one of the things I tell people is to be very cautious when you're talking to BP. That's not the interim claim process I view differently because it's run by a kind of a third-party contractor that BP has hired. But if you walked up to a criminal on the street and asked them for their help and they told you to do something, would you believe them? Well, of course not. That's the same situation you're dealing with BP here. So keep that in mind. They don't want to play fair, and this is our chance to try and even the playing field. And then you also have state common law claims. Those are things like negligence, strict liability, that as of Wednesday, we didn't know would exist in Florida because of a case I'll talk to you about. But now, because of what the Florida Supreme Court did on Thursday, these are good, solid claims. Now, recoverable damages. That's one thing a lot of people want to know. What can I recover? You can get your lost profits. That's business losses, rental losses, lost wages, those types of things. You can also recover for impairment of earning capacity. Now, that means a lot of different things to a lot of people. And right now, under the Oil Pollution Act, it has not been specifically defined what impairment of earning capacity means. It could mean that you had a business project you were working on, and because of the spill, all your business partners pulled out, and now you're not going to be able to establish this business, and it's affected your earning capacity. It could mean that. It could mean you have a second home condominium on the beach that you don't rent, but you could rent if you wanted to, and now you can't. That could be an impairment of earning capacity. We don't know if it stretches that far, but it could. So those are things you need to keep in mind when you're trying to figure out how you've been affected by this, and that's where we can kind of help steer your thought process as far as what your potential legal remedies are. You've also got loss of use and enjoyment of your property. Now that's not something that you can put a hard number on. You can't do it. But everybody knows the way you use your property out on the beach is affected by this. I mean, you've got smell, you've got all types of different things going on. That's a legal recourse you have that in front of a jury, they can put a number on that and say that's worth, whatever the amount is. It's a difficult thing to prove because, like I said, I can prove all day that you use your property differently, but it's hard to prove what that's worth because you can't tie a number to it. Then you've also got actual damage to the property. That would be something like a diminution in value claim. Because the oil has impacted your property, it's worth less. That's good common sense. But because of the law in Florida, good common sense doesn't always prevail. And I'll talk to you about that a little more. So that's what I was saying. What about diminution in value? There is absolutely, without question, the reality is property values on the beach are affected. They're affected right now, even though, right now what we have is tar balls. We don't have the oil sheen washing up on the beach, in mass quantities. But buyers aren't going to pay the same today as what they would have paid on April 19th. That's, makes sense. But unfortunately, the law in Florida requires an actual impact to your property. Now, what does that mean? If you own a condominium, does oil actually have to get on the wall of the condominium? Possibly. That's unfortunately how the law works. You also have the issue we have here of Escambia County actually owns the beach. So it's actually their land that's being impacted. So that could mean for everybody that owns property and has the leasehold interest out at the beach that they can't bring a diminution in value claim under Florida common law. The other problem we have with the law in Florida on diminution in value is the way they establish what your damage is. Your damage is the lesser of either the cost to restore the property or the actual diminution in value. So think that out. What does that mean? It could mean that because BP is going to be doing the cleanup on the beach, that's the cost of restoration, so the cost of restoration to you is zero. So what do you get? You get the lesser of your cost of restoration or the actual diminution in value. Well, the cost of restoration to you was zero. It's a horrible system, but it's the system in which we're having to deal right now, which is why we went forward, one of the reasons we went forward with this RICO complaint, because we believe that this is going to be an opportunity to move beyond what Florida's state common law is and apply some federal law to this and get actual diminution in value for people's properties. And not just that, but RICO provides treble damages. So that means you can get the actual diminution times 3. So that's why we've gone that route, seeking a remedy for people that we believe don't have a very good remedy. That's not to say that there's not the potential to bring a diminution in value claim. I'm not saying don't bring them. What I'm saying is it's our view of the law that it's much murkier water. And so on this RICO complaint, what we have done is we have a class representative, and that's actually Robert, has agreed to do this on behalf of the entire community. And for someone that does environmental law and class actions, I've tried to explain to Robert what he's getting himself into, and I hope he's listening to me. But BP's not going to be easy on him. But he is going to be out there as your representative in this case. He's going to get deposed. He's going to have to open up his personal finances to discovery, and they're going to come hard after him. But because of this class, if we're able to get it certified, we don't actually have to have everyone as a client. So what will happen is at some point a motion for class certification will be filed, and the court is going to decide, is this a proper class action? If it is, everybody that's in the defined class, which is, you heard how Mark described what it was, has to make a decision. Are you going to opt out of the class and go your own way? Because you still have that right. We can't take that right away from you by filing a class action. And if you don't want to participate in the class, you can opt yourself out of it at the point the class is certified, or you can stay in and let the prosecution of Robert's claim tie your claim along with it. That's how a class action works. So that option is out there, and it's something we believe is going to give a remedy to people. There's also the escrow fund as a potential remedy for diminution in value. Like I said, we don't know what the process is, but if I don't own property out here on the beach, but if I did, I'd file a claim on the fund once it's set up for my diminution in value. What's the worst they can say? No. So it's no loss. So I'd file that claim and see if they'll pay it. Now, the Oil Pollution Act also covers diminution in value, but BP is going to argue again that that requires actual damage to your property that you own. And they've got support in the law for that. And then what this Chapter 376 that I've got listed here is a Florida statute that's strict liability. All you have to do to show liability to BP under Chapter 376 is there was a discharge of oil. That's it. That's a pretty simple case to prove. I mean, you walk in front of a jury and go, picture, and you win. Because you don't have to show negligence or anything like that. You just have to show it's their oil. But you still have the damages problem of the lesser of the cost to clean it up or the actual diminution. Now, and I'm going to start moving faster through some of these because I know you guys want to get to questions. I've kind of laid out here who the majority of the defendants are and what your legal theories are. The primary defendant that everybody knows about is BP. BP is covered by the Oil Pollution Act. They'll be covered by the BP Escrow Fund and all other potential remedies. Transocean is the company that owned the drilling rig. Now, Transocean's already saying publicly, we weren't really running things out there. That was BP telling us what to do. And from what I've seen, they're right. There's a company man on the rig that no matter what Transocean wants to do, the company man from BP calls the shots. And he was calling the shots. But Transocean is covered by an act called the Limitation of Liability Act of 1850. Yes, it's that old, and it's still on the books. And what that allows them to do is limit their liability by filing essentially a complaint. And that's what Transocean has done. They have filed that in the Southern District of Texas, and they're seeking to limit their liability. And this is how they establish what the limit of liability to Transocean is. It's the current value of the vessel and its cargo. Well, the current value of the vessel is zero. It's 5,000 feet on the bottom of the ocean. But the cargo, the oil, is $27 million. So Transocean's trying to limit its liability to $27 million. Now, I don't believe they're going to be able to do it. The reason they filed this was to get the case in Houston, which is where the oil industry wants all of these cases consolidated. That's why they went there. But the important point of what I'm saying is to preserve your claim against Transocean under the current law and orders out of the judge in the Southern District of Texas. You have to file an answer to their complaint and a claim by November 15th. Now, you don't have to set out specifically, these are what my damages are, because you're likely not going to know that on November 15th. But you have to, there's filings that have to take place, and they're required to go out and publish notifications to any potential people. And I've seen those in the Pensacola paper where they've published these notifications that if you want to pursue a claim against Transocean, you've got to file in this court. Now, fortunately, it looks like Congress may get involved in some of this and get rid of the Limitation of Liability Act, which its purpose is largely gone, and hopefully that'll happen, and we just have to cross our fingers that Congress does the right thing. You also have Cameron. Now, Cameron is the manufacturer of the blowout preventer. Maybe many of you had never heard of a blowout preventer prior to this, but I think we all know what one is now. That's a strict products liability case. In Florida, there's a 4-year statute on that. Cameron is not covered by the Oil Pollution Act. So all this stuff with the escrow fund and the Oil Pollution Act, it's not going to apply to Cameron. And then you have Halliburton, who's the company that did the cementing job. We believe Halliburton was negligent in that, but Halliburton's going to claim they were doing what BP told them to do. But also, they are not covered by the Oil Pollution Act. So it's a straight, claim under negligent strict liability. Now here's the Oil Pollution Act. I've talked about this a little bit, so I'm going to move through it quickly. There's 2 sources of recovery under the Oil Pollution Act. You can either go to a government compensation fund or the responsible party. The responsible party in this case is BP for most intents and purposes. Transocean was listed as a responsible party for a very limited purpose that's not going to affect most people. It's a strict liability statute, so you don't have to show negligence. You basically just have to show that the spill occurred. I've talked a lot about this, so I'm going to flip through it, but this is the damages that are recoverable. The primary one people are interested in here is the lost profits or reduced earning capacity, but there's also, the ability for the county to recover for tax sales and all types of stuff that the county's losing under this act. Limitation of liability. Currently, the Oil Pollution Act limits BP's liability to all of the cost of cleanup plus $75 million. Now, we weren't worried about this $75 million cap to begin with, because all you have to do to exceed it is show gross negligence or the violation of a federal safety standard. That would have been pretty easy to do in this case. But because of this BP escrow fund, BP has agreed not to assert the cap. So we don't have to worry about the $75 million cap anymore. That's off the table. Now, how does OPA work? We've all talked a lot about the interim claims. I'm not going to go through great detail on that. But essentially, at some point, like Mark said, once the oil is stopped and we know how much has come out, we can forecast what damages into the future are going to be. And that's what you're going to need to know. You present that claim to BP. They then have 90 days to pay you the value of your claim, negotiate a satisfactory settlement with you, or deny liability. If they don't pay you something you're happy with, at the end of 90 days, you can sue them under the Oil Pollution Act. Now, you could sue them tomorrow for negligence, strict liability, but there is a case in Texas in federal court that says you could not amend in, what we call amending in the Oil Pollution Act claim once you've done the 90-day presentation. So that's why we've told people to kind of hold off a little bit on filing their personal oil pollution lawsuit and the other lawsuits because of that reason. Because prior to Thursday, the Oil Pollution Act was really your only clear vehicle of recovery. This is the presentment. It is absolutely, you have to do it or you will be dismissed from court. And you have to provide them what's called a sum certain. Let me flip through this. The sum certain, it's very specific. You have to say, I want this specific amount of money, and you have to document how you're coming up with that number. So that's why it's important on a sum certain, and that's why there's some, because right now it's kind of hard to determine what that sum certain is. If the wellhead gushes for the next 6 months, that's a big difference than if they get it stopped tomorrow, or if they'd gotten it stopped a month ago. So we have to know these kind of things to be able to forecast what the damages are. Now, interim claims. Some people don't know this. BP's not doing this out of the goodness of their heart. It's required by a federal statute. They are required to come into these communities and provide relief for short-term damages. Now, they've done a lot of PR trying to make it sound like, look what we're doing for you. But they're not doing it voluntarily. All you have to do is you call the claim center, and the number is 1-800-440-0858, and get your claims number. There's very basic documentation that is needed for BP to do this. Now, they're going to ask for a lot more than what is needed. But that's why we've been telling people, and what we found in the process of doing these interim claims, and Mark is right, we will certainly help. But what we have found is us getting directly involved slows it down, because BP doesn't want to deal with the lawyers. And then to some degree, you know, I call BP, I talk to them, they tell me something, then I got to get it on the phone and call you, and me and you got to touch up, and then I got to get BP back on the phone and talk to them. It's a lot easier if we can sit in the back and kind of advise you on it, and you can deal directly with BP. This is not overly complicated. So we've been telling people, go to your accountant, get these basic documents from them, and submit it to BP. And then just, you know, take what they're giving right now, because this process is going to stop sooner rather than later, most likely, with this fund. But certainly, to the extent you have questions on the interim process, or if you just need help, give us a call. We'll help you out on it. Now, the escrow fund, like Mark talked about, it's $20 billion over 4 years by BP. They've been required to put aside $20 million of their U.S. assets to secure the fund. They're going to put in $3 billion by the third quarter of this year, $2 billion in the fourth quarter, and then after that, $1.25 every quarter. We've been told, and it's in everything that's out there, that this fund is neither a floor nor a ceiling. What that means is if people submit their claims and it's less than $20 billion, BP gets the money back. If people submit their claims and it's more than $20 billion, BP is going to have to put up more money. This is not a limit of their liability to $20 billion. Frankly, I think it's going to cost a lot more than $20 billion once we see what the entire ramifications of the spill are. Like I talked about, BP has agreed not to assert the $75 million limitation of liability. The fund is designed for individuals and small businesses. It is not, governments won't be participating in the BP escrow fund. They will still be dealing directly with BP. It's also going to be used to pay claims adjudicated by the claims adjuster, who Mark talked about is Ken Feinberg, but also judgments and settlements, according to the information that's been released upon it. What we don't know is the law that's going to apply to this fund, and how the claims adjuster is going to be reviewing these funds. They haven't developed the standards yet, but that is what they have been tasked to do, develop standards for recoverable claims. They are supposed to do this as expeditiously as possible. Now, what does that mean? Who knows? The mandate they've been given is handle the claims no longer than allowed within the existing statutory time frame. But, I mean, I've read this I don't know how many times. I can't tell you sitting here today what statutory time frame means. It could mean one of two things. It could mean 3 years, which is the statute of limitation, and Lord knows I hope that's not what it means. The other it could mean is 90 days, which is the time under the Oil Pollution Act that people have to submit their claims in BP to pay them. Hopefully they fix it, because even 90 days is too long, as Robert talked about. They have got to get on this, or businesses are going to go under, and they don't seem to be getting this into their head that if you wait 30 days and pay people at the end of the month, they're not going to be able to make their payroll and pay their notes and do all these things they've got to do. So we've got to come up with a more streamlined process, and what we're trying to do is get with Mr. Feinberg and others to convey some of these ideas to them on how important it is that you can't sit back and wait on this, or it's going to be too late. Now, if you're unhappy with what happens with the claims adjudication process, you can appeal to a 3-judge panel. So that's good. And if you're not happy with the decision of that 3-judge panel, you can file a lawsuit. So you've still got all those remedies available to you if the claims process doesn't work the way you want it to under the escrow fund. And then the really nice thing about this is BP doesn't have these same appeal rights. The decision of the claims administrator is binding upon BP. So they don't get to go to this 3-judge panel or then file some sort of lawsuit if they don't like the way the claims process worked. Now, I'm just going to quickly do this part because we need to move on. But what I wanted to talk to you a little bit about is what happened this week in Florida with the Florida Supreme Court. There was a case in the 2nd District Court of Appeal called Curd versus Mosaic Fertilizer. And it was a situation where fishermen were affected by a chemical spill, and the fish died. And the fishermen brought a lawsuit and said, look, I can't fish and run my business because all these fish are dead, and this guy caused it. And the 2nd District Court of Appeal, I'm going to simplify it a little bit, but the 2nd District Court of Appeal essentially said, you don't own the fish. So because you don't own the fish, you don't have a case. It doesn't matter that you live off of the fish. You don't own them. So you can't expect to be able to bring a case. And they threw them out under negligence, strict liability, every possible claim you could bring, threw them out. Now, they took some extreme liberties with the law in the 2nd District Court of Appeal, and we've been crossing our fingers for well over a year at this point, hoping the Florida Supreme Court would fix this, and on Thursday, they did. They reversed the 2nd District Court of Appeal, and they said, no, 2nd District Court, we have said in previous opinions that just because you don't own that property, if you have an economic interest that you make your living on, you've got a claim. People don't get to avoid liability because they damaged a resource the public use to live and then walk away scot-free. That's not how it works. So thankfully, the Florida Supreme Court has taken care of this problem largely for us. And under Chapter 376, strict liability, I believe every person on this beach has a claim under that statute, and they can recover, the statute says, all damages. And the only defenses BP has are things like acts of God and that kind of stuff. They're not going to have defenses. And the way the Florida Supreme Court dealt with this is they said that, in the fisherman case, the fact that they don't own the fish is not a defense listed in the statute. So because it's not in the statute, you can't use it. Well, guess what? The fact that people don't own the land out on the beach is not in the statute. So to me, that would mean that everybody can bring a claim under Chapter 376. Now, whether or not, again, the damages question is a different question, but at least we get in the door. So that's where we are with Florida law right now. I think I've covered, maybe to mind-numbingly detail, what the law is on this. There's certainly a lot of areas I haven't covered, but we're going to open it up to questions pretty soon here after we have a couple more people talk quickly, and I'll try and answer any questions you've got. If you've got a question that doesn't get answered, call me, and I will talk to you about it, or grab me before I walk out of here today, and I'll talk to you about it. We're now going to turn it over to Mort O'Sullivan, and Mort is going to talk quickly about what kind of documentation you need to hold on to be able to show your damages.
By now, I know your legs are tired or your seats are sore, and I owe it to you to be succinct. Am I being loud enough? Recognize that these interim claims are, the BP process is trying to simplify it. Don't let it lull you to sleep about your record keeping. It may be simple in filing the interim claims, and it could consist of only your P&L statements spread by month, your sales tax returns to show them you did not make up your P&L statements on Excel, and your income tax returns you filed for the last 2 years. that could be as little as you may need for an interim claim. But you need to maintain records that will be required in your ultimate claim against a $20 billion fund or in a court of law. So be careful. Copy all of your financial statements for the last 3 years. And I urge you to build this file now because the storm season is upon us. I've lost records before in previous hurricanes. Get these records in a safe place. If you choose to scan them and digitize them, you're probably more secure in doing that. But just put yourself in position with these records. All of your monthly financial statements, your bank statements for the last 3 years, a sales breakdown by month for the last 3 years, your business tax returns, as I just mentioned. For all of you who own rental property, all your email correspondence and cancellations that you've had, you know you need to document those. Photos of all your property that has been affected by this spill. If you happen to have tar balls or oil on your beach, make sure you have that in photographic form. Ultimately, in your claim, Ned McWilliams at the Levin firm saw how frustrated I was as accountants, us, our friends at Salt Marsh, Sheldon Burnett is here, I saw him. We want our clients to get the most they can now with exact precision. And what we're hearing is BP isn't going to do that now. So we're surrendering to go to the simplified BP method, which early in the week says we'll pay you for revenue loss compared to the same month last year. Midweek they said we'll pay you based on last year's revenue plus 10%. So get this together now, but ultimately you're going to be able to establish trends. And we had a cold winter here, so out here on the beach you probably didn't see upward trends in January, February, but it began to turn in March and in April. And so even if it's on a weekly basis, ultimately see if you can establish where you had began an upward trend this year. It will be important long term. Do document and copy your QuickBooks files. Things happen to computers. Make sure you've got a good backup for it now. You will be in contact with people throughout this process. Keep a daily journal. We've had people say to us that really does help. You'll forget things as this goes on. We learned this from hurricane experience. Your mind numbs, you forget. Keep a daily journal. Talk about who you've seen, what they've said, and document all names and phone numbers from people you've spoken to at BP or in any of the regulators. Document everything you have. Lastly, on the loan comments, that SBA loan program has been helpful for some already. The Florida Emergency Loan Program, yes, it's only $5 million, $25 million max. That could be as short as 200 or 300 claims, and that fund is out. But the website for that claim is FloridaOilHelp.com. If you go to that website quickly and you need the money now, you can get up to that $25,000 loan. It is interest-free. You do have a 12-month term to pay it back, and the website will show you what documentation you have to have. You take it to the SBDC office on 9th and Chase. Once you've gotten the form off the internet, filled it out, you present it at that office. And finally, do pay attention to the letter in the Levin package that's here. There's a 3-page letter. Read it when you get home. It outlines very clearly some helpful hints of what you do in filing these claims. There is a process in which, although represented by the firm can give you the documentation to hand to BP that will authorize them to speak to you directly and speed up the claim. We're glad to answer questions when this is over. I think I want to be short for you at this time. Thanks.
At this time, we'd like to call up Lois Benson, a former state representative and a current member of the Escambia County Utilities Authority. Lois.
Robert, first of all, thank you for putting this together. This has been wonderful information from all of you, Mark, Brian, Chips, Mort. I have a little tiny piece, and I'll be quick. Karen Hendricks called me and said, we all want to do our part in cleaning up, and we need some help. Would you please just get us a dumpster so we as homeowners and neighbors can dispose of these tar balls? And I said, sure, sounds like an easy thing to do. A day's worth of telephone calls later and many, many roadblocks later, we finally have arranged to get trash cans in neighborhoods along Pensacola Beach so that we can dispose of these tar balls. Please be aware that you shouldn't handle them with your bare hands. Make sure you have some sort of rubber gloves or something on them. These are toxic materials. Also, double bag them when you put them in these containers. But put them in these containers, not your trash cans, because the trash cans go to the landfill, the oil can leach into the aquifer, and we have another huge problem. But use these. We should put them out on Monday. We're going to get with Buck Lee about exactly where they're needed. But I think all of us want to do our part, even if it's one small part in this cleanup, and this is one way we're trying to help. Thanks.
Thank you, Lois. Now we have about 15 minutes left. We're going to open this up to questions. Is Chip still here? Okay, we'd like everybody that is presented today to be up here so that they can field questions. I'll repeat the question. The question was, how is the potential concert series going to affect the turtles with the lights coming in from the Gulf of Mexico? It's a great question. Obviously, there's nobody that can violate those laws and codes, so they would have to deal with that issue by the way they faced the stage and dealt with the issue.
As I said before, as we go further into the class, there may be some amendment process. You've got to be careful when you file a class action suit on the definition of the class. The broader it gets, the more chance there is that the court will refuse to certify the class. And if that happens, then individuals are left to bring their claim alone against BP, and you obviously can see the fallacy in that. With some of the new changes in law that Brian talked about, we think that those properties may now be covered under Florida law for diminution in value claims, but in terms of the specific class, they would not be covered, and we'll be looking at that as the class moves forward.
We already have a claim number for loss of rental income. Do we need a separate claim number for diminution of value?
Most likely, no. If it's for the same piece of property, same address, no, you shouldn't.
I have a couple of properties for sale right now. Obviously, value's going down. Do I need a claim for those?
It can't hurt. I mean, if you want to file an interim claim, you have to have a claim number. So get the claim number on the properties. That's why you already have it. Now, remember, the interim claim process is for short-term damages. So you could make the claim for diminution in value and just see what happens. But even if they said no, it doesn't foreclose you from bringing a lawsuit at some point in time once everything is trued up. It would just mean that BP is not willing to pay you on the interim process. One thing to keep in mind on this interim process, if you take a check, if you don't take a check, if you enter the process, if you don't enter the process, this does not affect your ability to pursue all legal remedies against BP so long as you do it within the statutory framework and the statute of limitations. You are not releasing your rights by entering into the interim claim process or even accepting a check. The one thing I would tell everybody is before you sign anything, have a lawyer look at it. It could be, it doesn't have to be us. I'd love it to be me, but have a lawyer look at it, because in the interim process right now, they aren't requiring people to sign stuff. They're giving you a check, you deposit the check. You don't have to sign anything. And if they change it and hand you something to sign, they're doing something different. So have somebody look at it.
If there's a hurricane, should people now be concerned about their coverage? Should they purchase more wind coverage? I just got an advisement from my insurance company. I'm out there on the point. Would BP be liable? Will we have to go to the insurance company if, in fact, we occur oil on our property? What is your opinion?
most insurance policies that I've seen, and I haven't seen them all, have a pollution exclusion, and a lot of them specifically have an oil spill exclusion. So it's quite likely that your insurance policy is not going to cover the loss from the oil. BP would be responsible so long as we could show it was BP's oil. Now, that's, people laugh. Hopefully, we don't have to face this issue. In the hurricane, we don't have a big storm surge, and oil doesn't wash up and affect a lot more than, it's obviously going to affect a lot more than coast. That's not what I mean by that. But the oil itself doesn't actually get more inland. But if it happens, I promise you, BP is going to say a lot of it's not theirs. They're going to say that came out of this person's yard, that came from that gas station, that came from something going on at the Naval Air Station, that came from here and there. And one of the things we're doing right now in part of the litigation process is we're getting actual samples of the source oil that we can test, so we'll have a fingerprint of what it looks like. So if something like a hurricane does happen and the worst case scenario does occur, we can test what's on the property and trace it back to BP to show it really is theirs. If the policy doesn't specifically exclude oil or a pollution exclusion, then it probably is a good idea to buy it. But they're all so different, and anybody at the firm will be happy to look at it. So just you bring it in, we'll look at it and be able to give you some better steerage on that. Yes, sir. It's a good question. The question was, in the past, when hurricanes have come ashore, the government has declared this a disaster area, and then that's when FEMA comes in and takes control of everything. Now, my suspicion is one of the reasons the government hasn't done it is the government doesn't want to pay for it, and they're trying to get BP to pay for everything. That's my suspicion. But as far as why they haven't, I can't answer that. I personally, I would rather see somebody like FEMA administering more stuff, but hopefully at least this claims process will get better. But as far as the cleanup, look, nobody that lives around here is happy with the way things are going out there. BP looks like the Three Stooges with everything they do. And they come up with a catchy little name for it. It's all a PR stunt. If you ask me, everything they've done out there is a PR stunt. They know the only thing that has any chance of really working is the relief well. Even the use of dispersants is a PR stunt. They want to keep the oil off the surface. But to some degree, it's a very, BP spent billions of dollars already doing what they're doing, and the government is trying to make sure they continue to do that. And if it's BP's money, they have a voice into how the government uses the money. But no, we're all disappointed the government hasn't gotten more involved and started to take over some.
How do people quantify before they get to that last stage where they're going to file what damage could be done if there's a hurricane? That might happen after they file. How do you quantify that? How do you?
Well, one thing the law doesn't do real well with is what's called, speculative damages. We can certainly forecast, once they get the well stopped, how much is out there. Environmental experts will be able to come in and say, this is how long it's going to take to clean up. These are the resources that are going to be affected over this period of time. This economist will be able to come in and say, in other situations, we've seen economies affected for over this period of years at this percentage. So we can do all these forecasts, but the one thing we can't predict, you can't throw in something like a hurricane. We just have to hope that it doesn't happen. But, if the lawsuit were pending, we could always amend it and say, now something else is happening and it's made it worse and we're amending our damages. But, a lot of times in the law, something that happens 5 years later really changes things, and it's hard to predict at times like that. The BP may even try to use something like an act of God defense if a hurricane comes in and says, well, how could we do that? It was an act of God. There's a lot of different things out there, and the bottom line is, we've never dealt with a spill like this before. And that's one of the problems with the Oil Pollution Act is, it was designed for a discrete spill, something like the Valdez, where it hits a reef and a bunch of oil comes out. We know how much oil went out. We know over what period of time. That was a tragic situation, but we can forecast it better. This situation, because of the idiocy that's going on out there, BP is able to take advantage of your ability to even bring a suit because of this 90-day presentation requirement, because you can't project what your damages are until they get it shut down. So they're getting an extreme benefit out of this that I frankly think is just wrong. And every congressman I've talked to, I've said, please get rid of this 90-day requirement. But, the answer I always get it from congressmen and lobbyists as well. Congressmen don't understand that issue. They'd rather talk about the $75 million cap because that's an easy issue. But, it's tough.
I think this question does illustrate a significant point in terms of when you ought to be consulting a lawyer, whether it ought to be in the interim claims process or the final claims process. At some point in time, the interim process will be over. It's one thing to file your own interim claim. We've worked out, initially BP was requiring releases. If somebody got interim money, we put a stop to that, so that should not be a problem. You'll be able to take your interim claim money without prejudice to your right to bring a future claim. But at some point in time, you will be required under the law to file a claim for the sum total of your damages. The damages existing now and the damages that you can reasonably project in the future. And it's that future projection that Terry's question goes to. You need to make sure to properly assess what is recoverable under the law in terms of damages into the future. That's when you need legal advice, because there's going to be a lot of different assessments that go into that determination, a lot of different applications of expert testimony and opinion, and that is not something that, in my view, you're going to be comfortable, nor should you be, doing alone. If you own, the question is, if you own a home and live here, should you file an interim claim? Only if you feel that you have been damaged now. Typically, that is easier to prove in a rental situation. I've had these cancellations because of the oil spill. I rented my home or condominium last June, and I recovered this amount of money in rentals, and this June it's this much less. That's obvious damage. It's not as easy to quantify on your scenario, because what you're talking about is a diminution in value claim. I think you can get a claim number. I really don't see the necessity or really the advisability in bringing that claim now. I think it'll be quickly denied. And I think, candidly, you won't have a real good idea sitting here what type of diminution you're talking about. One of the things that we are doing is we are working with and counseling with the various property appraisers in the affected counties. We're very well aware of the tax situation here at the beach and all the legal ramifications and innuendos of that situation. And the property appraisers are very concerned with the devaluation process as they relate to the current tax bills that you'll just be getting in the mail, as well as future taxation issues. There's legal impediments to changing those assessments for the current tax years. So we're working with the property appraisers to try to advise them and counsel them as to what might be necessary in terms of special acts if, in fact, we are dealing with a massive devaluation. The other side of the coin is you want to be a little bit deft about the way you handle this. We don't want to propel ourselves into by virtue of undue publicity, a massive immediate devaluation. So I think that there are certain situations where if you've got damage, file your claim for damages. But I think it's probably inadvisable, because you can't win, to hoist a white flag at this point and claim that the property at Pensacola Beach, including yours, is worth nothing. So I would recommend that you just keep your eye on that. We'll have more information as the weeks and months go on because of our work with the various property appraisers. Obviously, we all fear that it's going to be an issue, but I think we've got to be a little bit coy right now about the way we handle that.
Okay, guys, I want to wind the meeting down. Thank you so much for being here. Levin and Rinke's goal, Resort Realty's goal in this is the island's obviously been very good to us. All of our partners love living here, and we are going to continue this on a monthly basis as things are changing rapidly. Our goal is to bring in the right experts, whether it be accountants, scientists, public health officials, lawyers, anything we think can be helpful and informative to the island. We want to bind the island together. This is not a defeatist group. This is a high-spirited island here that will get through this. This is not the end of the world. We also do want to set up this concert relief series and keep the pressure and the attention on making sure it never happens again and getting it thoroughly resolved. Also, I think Mort O'Sullivan wants to end something real quick.
For those who have particular detailed questions on the interim claims, my partner Jeff DeWeese from O'Sullivan Creel, Sheldon, raise your hand. Sheldon Burnett from Salt Marsh Cleveland Gun. If you'd come up here at the end, the three of us will gather those with particular questions that we didn't want to tie up the whole audience on. So we'll hang around afterwards. Thank you.
And I'll do one correction on Brian Barr's. Mark Proctor and Fred Levin did not give me a choice in filing that lawsuit. But they did tell me it's more fun to be the suer than the suee. Since now I'm going to get the chance to see how that works. Okay.
One last announcement, and then Robert will close it out. Mark Randall from the SBA is here. He's extremely knowledgeable, he's extremely helpful, and he's advised me that the SBA has actually set up an office in the Casino Beach parking lot. They will be there today and next Saturday and Sunday from 8 to 5. So if you... Next Friday and Saturday from 8 to 5. If you have any questions, go see him. We've talked to him. He's been extremely helpful to us on behalf of clients, getting information out, and he's right across the street, so take advantage of it.
A last final word on real estate. This island does not have a large glut of inventory like a lot of the United States does with resort real estate. We are not in a dire situation with over inventory. We encourage all of our clients to not sell their real estate in a down market. This is a down market. A lot of the excess inventory got eaten up this year and last year. Once again, this is not the end of the world. We'll get through this. Our property values are already so low, they were actually on their way up. So we just want to keep a positive frame of mind and put the right things in place and all get through this. Thanks everybody for coming, and look for another letter and a postcard. We'll be following up on a monthly basis. Thank you.